welcome Terry Bonnette, Deborah Brouwer, John J. Conway, Daimeon Cotton, Courtney Nichols, James Reid IV, with moderator Joshua Lushnat.
Good evening, everyone. My name is Josh Lushnat. I'll be moderating this evening's panel. I'd like to have the panelists introduce themselves quickly.
That's better. My name is JJ Conway. I have a small boutique employee benefits practice in Royal Oak.
Good evening. My name is Courtney Nichols, and I'm a partner at Plunkett Cooney in Bloomfield Hills.
I'm James Reid IV, as they announced. The fifth is at home, so the pressure's off. And I'm a partner at Dinsmore and Shaw, and I practice employment law.
Good evening, Daimeon Cotton, and I handle employment issues. If it happens at work, I'll probably handle it.
I'm Deborah Brouwer from Nemeth Law.
And I am Terry Bonnette from Nemeth Law.
So for our first question, and if anyone has any questions, feel free to chime in and ask away. Certain employers, maybe law firms, are a little more lax on policies than other employers. In each of your practices, what are some policies that you think are perhaps undervalued by employers until a situation or an issue arises?
I always see a tendency where lawyers aren't afraid to share their opinion, especially with other lawyers. And I think that it's often too common to have opinions about the skill set or the personality or the workload abilities of other lawyers, and not everyone knows everything on their plate and what they're doing. And I think we should have a policy where you don't spread rumors and talk to higher up people about someone. You first try to resolve that situation one-on-one, because I think a lot of lawyers get burnt out, get a bad brand, and they feel like they're set up to fail instead of set up to succeed. So some type of mentoring system where it's resolved at the first level before it gets escalated to, a board where their perception is tainted.
And in smaller law firms, you generally, as Josh indicated, won't have traditional employee handbooks. So one of the things that I run a small law practice, and one of the things that's important, and I think that employers might take it for granted, is to have some sort of documented guidelines, process, procedures in place. So one of the things we do at my office is that we use inter-office memos a lot. How do you draft an interrogatory? A lot of times I'm a millennial, but I'm still sort of old school where I dictate. Just for the millennials, you may not know what that means, but I'll dictate out just what those processes are, whether it's drafting interrogatories, whether it's how to file a complaint in federal court versus state court, put it in a memo, send it to a paralegal, and then they document what they do. I have them respond either to me when they let me know what they did to accomplish that task. And before you know it, it may be onerous in the beginning, but before you know it, you have a policies and procedures handbook so that whenever you have to miss work, and now with the pandemic, it seems like every day people have to call in and have to miss work, but now the next person can step up, pull the memo from such and such a date, such and such a time, such and such a file, and know what to do with it. So for small practices, I believe something like, even if it's not a traditional employee handbook, just a rules, policies, and procedural document is going to be very beneficial.
Well, I would actually expand on what Daimeon just said, and I think it's pretty important for all employers, especially law firms, to have employee handbooks. It doesn't have to be anything massive, doesn't have to be hundreds of pages, but employees need to know what's expected of them, when they should come to work, how often they should come to work. And I think it's a good idea to have things like that in writing to help your employees.
From my perspective, at a mid-sized to large firm, the things that have helped us really get on track and have some extremely profitable years have been what we call the best business practices policies for attorneys, because they're not always going to read the handbooks and things like that, although they should, and people like me harass them to do it daily. We have a quick fact sheet about better business practices and best business practices. So things in terms of entering time and getting your pre-bills out and getting your receivables checked out. And those are things that are enforced by a best business practices director on a daily basis. And since we've had that policy and the level of enforcement that we now have, we've seen a huge success, a downturn in old money that can't be collected, and upturn and candidly client satisfaction with our services as well.
I have a question for you, Courtney. How do you enforce that?
We have a
what does that best practices person?
We have a former litigator who shall not be named, who retired from her very contentious litigation practice, and our current CEO was like, "You would be the perfect person for this." So she comes in and she gets notifications about who's not completing their pre-bills, who's not, or who's cutting too much time from pre-bills, who's not monitoring their receivables, who's not entering time timely, and she literally harasses them within the boundaries of the law. She calls them, she sends emails. If they don't respond, she CCs our CEO, and that's her job. And she's paid and she receives a bonus and all the other stuff. And she loves it because that's very much with her personality type. But short of the best business practices director, there was problems with enforcement, right? Like we did have the serial attorneys that constantly just don't do the little things that if you were running your own practice, you have to do to keep the lights on. So that has been helpful.
So we're at a 29 office larger firm, and we don't have someone like that in all 29 offices. So we actually automatically charge the lawyer $100 if their time isn't entered timely, and another $100 if their bills don't go out timely. And after that comes out of their paycheck, they start to comply pretty quickly going forward.
All great ideas. So it's no secret the pandemic has changed the practice of law. It's also changed the employment relationship. We have attorneys that practice on both sides of the V here tonight. What are some things you're seeing, some metamorphosis or some changes to the employment relationship due to the pandemic?
Well, one of the things that I've noticed, so I represent plaintiffs on the employee side, and plaintiffs want their cases heard like yesterday. They want trials like yesterday. They do not want cases delayed. And unfortunately, with the pandemic, what you're seeing is that staff is is calling out being sick, judges, clerks, attorneys. And so cases are being delayed. And in addition to that, just the whole nature of what the pandemic has caused from an emotional standpoint. So maybe it's just me and my practice, but, on one hand, employees are, their employment law is much like family law, where it's an emotional situation anyway. But that aside, people understand that we're in a time where it's a sensitive situation. And so I guess you can say on one hand, people's appetite for straight litigation and let's go to war and I'm going to cut your head off and I'm going to chop you, that type of stuff is not as prevalent. And people want to be heard. They want justice if there is such a thing, but they want their matters heard expeditiously. And I think sort of the future, not of just employment law, but the future of the practice in general is probably going to be more towards dispute resolution, alternative dispute resolution. And why? Because one of the things that dispute resolution does is addresses that time delay issue. So assuming that you can get in front of a mediation and assuming that you can resolve the case, maybe you can mediate and resolve a case in January and you have a trial date of December of later that year. So that's a possibility. And I see more clients like that. And so that's something that attorneys should keep in mind as they're practicing.
Again, just spinning off something that Daimeon said, we do a lot of counseling of HR people and people who are making employment decisions for companies. And HR people can tend to be, not all, and if there's any HR people here, I'm not overgeneralizing, a little rigid, rules people. And our counseling, I think these days, is saying you have to be more flexible, you have to be more sensitive. People are stressed. The HR director is stressed, spending all day trying to figure out what the CDC is really saying. And so it's time to just sort of take some deep breaths and give people, cut a little bit more slack, expect that people are not going to come to work and you're going to have to deal with those issues and you can't be surprised and you have to be flexible and just go with this roller coaster that we're on. So so that's the advice that's a little different than before, pre-pandemic, when you could sort of just enforce the rules. Now you just have to be a little bit more flexible. And I'm sorry, JJ, I interrupted.
Oh, no, it's, it's interesting. And probably everybody here could speak to this to some level. When you're practicing in employment law and the various discrete groups within employment law, you do tend to see the trends. And when economic times are terrible, you're reviewing severance agreements. When economic times are going great, you're reviewing ESOP programs and stock options. This pandemic has sort of been an entirely new experience that none of us, I don't think, really had the training for this, and we're sort of learning as we go. But what I've seen sort of on a positive side of things is that if a tight labor market like this, which is extremely competitive, headhunters looking for lawyers everywhere they can find them to try and get them, and especially if they've got training, if they've got 5 years under their belt, they're just in a perfect space right now. That's the right amount of knowledge, right price point and everything. But I'm seeing, at least in the tech companies, that the way that they're attracting talent is to use tax advantaged ways to get money to people through another form of compensation using benefit plans. So generous leave policies, paid family leave, fertility benefits, benefits for people that want to adopt children. The plan designs now are looking more, since people have become more reflective during this period of time, of looking at that people want to create families, they want to care for families, and how can you deliver benefits to people in a tax advantaged way? And that's how employers are getting competitive. I think that's going to probably be the future of law too, especially at big firms. I think people are just going to demand this stuff. You aren't going to be able to attract talent. And so that's one of the real positive things I'm seeing, is that employees are getting very generous benefit plan offerings in a way that they never had before.
So that's a great lead into the next topic. We've heard this called the Great Resignation. It's a tight labor market. It's tough to find talent. It's tough to retain talent. What are some things that you all are seeing your clients do, or even your firms are doing, to attract top talent and retain the talent that you have?
Well, I think Deborah mentioned with HR people the need for flexibility. I think that's what law firms have to do in order to attract and retain talent. And I think that perhaps smaller law firms are somewhat at an advantage here, because they have the capacity to be more flexible. They're not tied into big programs that are already in place. I think what we're seeing, you talk about the Great Resignation. I think the pandemic has really made people stop to think, what's important? What is important to me? And it might not be the money anymore. It might be the time. So flexible work programs, the ability to work remotely, the ability to work in a hybrid situation. Even post-pandemic, I think that will be the new norm, that we've realized that we don't necessarily need to be in an office to be productive. And so to attract talent in the future and to retain talent, I think firms are going to need to have that flexibility to create a better work-life balance for their attorneys and their staff.
I would agree. As somebody at a firm trying to recruit and retain talent, that's been a huge thing, right? So we advertise that we are now a hybrid model. If that people can work entirely remotely, so long as they're being productive and meeting the objectives of the firm. We also really try to tout our transparency. So we have people that will interview with us and say, well, at my firm, I don't know what it's going to take to make partner. I don't know how my bonus is going to be calculated. I don't know what this is going to be at the end of the year. It's all discretionary. It's 3 or 4 people that are sort of making these ad hoc decisions, and that's problematic. I think employees want certainty. They want to know what the expectations are. They don't want to be overpromised and underdelivered. So to retain and to keep the talent, you got to keep your word and you got to be transparent about it. And I think that's a good first step, in addition to everything that Terry noted, which is exactly what I was going to say. That flexibility is really critical.
I was just going to add that the leadership style that worked in 2008, where your employees are lucky to have a job, isn't the same leadership style you have to have now. I'm seeing a major shift where it's not only vulnerable leadership, where you're explaining you're also going through a hard time. It's also empathetic leadership, where you're trying to understand that employee's point of view, help them accomplish their goals, and give them the career path, training, and education, not just do this widget work I don't want to do. It's how do I give them that experience to continue to grow? And if you show that type of caring and investment in your employees, they aren't going to leave you for more money across the street.
Just wanted to say that transparency, that's really key, especially for smaller firms. And by smaller, 10 employees or less. a lot of my employees and people I work with, they want to know sort of how the firm is doing from a financial standpoint. They want to know, okay, if I'm going to invest, if I'm going to take a trade-off from going to a larger firm or mid-sized firm, are we headed, what direction are we headed in? They want to see a vision. They want to see some room for growth. They want to know that the doors ain't, you're not just hiring me for one project and then you're going to be laying me off next week because the firm is going to file for bankruptcy or something like that. So transparency is something that I'm seeing a lot of employees are interested in doing. And I feel comfortable. I think that's something to be commended, to share not only the firm's substantive law, the vision in that regard, but also just from a financial standpoint as well.
Right. And I would just like to add that one of the issues that we're dealing with and we need to continue to deal with when we talk about flexibility and figuring out what kind of work-life program works for, and it might not be the same thing for all employees. Each employee might have a different work-life need. But one of the things that we need to keep in mind and address is that if we have these remote work situations, and as we're onboarding new employees, the other issue that I think is very important in retaining talent is creating that engagement and creating that connection with employees that work for you, but may never have been in your office. You may never have physically met the person face to face. So you need to put programs and procedures and policies in place that is going to get that person to engage with and identify with your firm.
Those are great answers. So you're all at various size firms and different experience levels. What are some things that you would recommend to employers who are trying to, or law firms that are trying to get to your level or your size, some proactive steps to look at doing, either that you've already done or you may be looking to do, to avoid employment issues as things progress or as you grow?
I can start on this. This is the same advice I give to my clients. It's communication. I think that clear communication is really important. I think that setting expectations and being, again, transparent, not to overuse the word, but to say these are the policies and this is what's going to happen if the policies are violated. All too often, I'm dealing with lawsuits, as I'm sure many of us are, where there could have been a 15-minute conversation that stopped all of this dead in its tracks. And that conversation did not occur because people didn't want to communicate. They didn't want to put something in writing. They didn't want to pass the policy, especially lawyers. We're so paranoid about anything being in writing and issued and what's going to happen, what's the fallout going to be. If you tell people this is what we expect of you, and if you meet these criteria, this is what you will get, I think that can avoid a lot of problems. And then sticking by your word, right? The worst part of communication is saying something and doing something differently. So it seems really simple and trite, but I think that that's important. Like, don't be afraid to tell somebody what the expectation is and what the consequence will be.
Yeah, I think to add to that point, you don't want to put everything in an email. And I think we're getting too lazy with remote work and communication where we're just emailing people, and employment attorneys especially feel like that's a document in their personnel file and that's a strike against them. And a lot of times that email communication can be misinterpreted. Like, what was that person's tone? So I sent someone an email like on the weekend a couple of times, and they thought I was like on them because I'm emailing them on a weekend. that's getting caught up. So like there's a communication style where people have to understand your style, what you're about, and what your expectations are. But another thing that our firm does is at age 65, you're no longer an owner of the firm anymore, and you're now a contract attorney. So you don't get to coast your final, era of years. You're a paid for performance player. And I think that incentivizes the rest to know that there actually is a chance they could, move up the ranks through just healthy succession planning.
One thing that I think this kind of ties in a little bit what Courtney was saying, what Deb was saying, is when you're in a Rust Belt city like Detroit and you're in an industrial region like Michigan, the history of employee and management relations has always been somewhat adversarial. It's in the DNA, and it's very hard to move past that in terms of how we look at this. There's a lot of reasons, a lot of history for that, but it seems to me that the companies that are really doing great stuff, the companies that are growing and are making the world move, are the ones that have changed that relationship. And so human resources in the tech companies, and I do think the tech companies have a great leg up on us in the manufacturing industries and that, which is they use their human resource departments almost like in a counseling capacity, because they've gotten the idea that human beings are the assets of those. They don't have any industrial machines, things like that. They really do believe in their people as assets. And so they take advantage of that. And so the employees are going to HR in those situations, not to report somebody or to complain about this. It's to try and get better, to try and reach the next level. How do they break through? How do they climb the organization? And those HR departments are helping them chart the course. There's real buy-in on that. And I look at that and I sometimes think we've just totally missed this here because we're stuck in this old way of doing it. Whereas if you change the dynamic of that, and especially at big law firms, I think that could be a real advantage.
So as a follow-up, we're seeing communication change, remote workers, doing things by email. We've talked about the good benefits and all the positives, but in the changing environment, how do you have kind of the more difficult conversations with employees, or what are the tips of kind of having that conversation? Because you don't want everything to be casual because it was in an email and people are working in different locations. Any tips from an HR standpoint or as a business owner?
Well, I think it's one of the, as Terry will tell you, I am not a fan of remote work, not at all. And I can list sort of more disadvantages, I think, than advantages, but maybe it's because I'm managing the firm and that's my perspective. But a difficult conversation over Zoom is not ideal. It's definitely not by email. If you're going to have a difficult conversation with an attorney or with an employee, I think you have to be very sensitive to the context and the presentation. And if there's any way to actually have that in person, to do that. Because, what we miss by teleconferencing and remote work is, first of all, we only see anybody's head and shoulders. I was surprised at how tall Daimeon was. And I've got cases against Daimeon right now. I had no idea. It would have changed every way I've done with him, built differently. You don't get all the cues. All you do is just see a big face in your screen. It's the same thing with depositions. We're losing the personal aspect of it. And if it's going to be a difficult conversation, I think you have to, if you can't do it in person, you have to be really aware of all of those downsides of doing things remotely, because difficult conversations have to be personal. I mean, not personal emotions, but they have to be human, person to person. You either want someone to improve or you don't. That's actually the easier conversation. That's the shorter conversation. If you want someone to improve, to get better, you have to connect with them. So any way that you can do that will improve that conversation. It'll make it hard, but it'll make it more successful.
Yeah, so I'm sort of in a unique situation where 90% of my clients are employees who've been terminated from work or have workplace grievances, but I'm also an employer. So having the advantage of seeing it from sort of an employee standpoint. But one of the things that I'm starting to do more now that I'm starting to hire people is that it's a lot more coaching, because whenever issues come up with whether it's law clerks, paralegals, or even attorneys, I know from my experience as a plaintiff side attorney how important it is to sort of document, I don't want to say discipline, but document whenever you're having issues. But not only document, but to explain sort of what's expected to address it and correct it. Sort of the way I address it now is probably not as formal as a larger operation, but I do have at least some procedure in place whenever I have to have that difficult conversation. And as Deborah said, it's difficult. I haven't had that conversation since the pandemic, but I can think of at least one situation where I had to, have that difficult conversation, and doing it in person, but then following up with sort of, in writing or however you want to look at it, following up with sort of the expectation about how to move forward. So from that standpoint, I think it's sort of necessary to keep that in mind.
I volunteer as the president of SHRM, so I hear all the 16,000 HR perspectives. And I think a common theme is to first make sure the leader is coming at it from a place of not anger and emotion, but what is the common goal and solution that we're looking to achieve. And second, not point the finger. I think start with some level of accountability as a leader. I feel that I could have talked to you sooner. I could have trained you more. I feel we can improve this. And by taking a level of accountability first allows the recipient to also have an opportunity to take accountability and be part of the solution and not feel defensive, where if you're making a conclusion that they disagree with, now you're losing trust. And I think the whole goal is to have strong trust with your team.
I'd like to point out quickly that we're talking about the human aspect of this, but there's a pragmatic, practical aspect of this too. If we're in a remote work environment and we're giving employees a laptop and a cell phone and an iPad and access to computer networks and sending them home, maybe in into an office furnished by us, and then we're having a difficult conversation and letting them go over Zoom, that conversation ends with, "Oh, and by the way, could you send my stuff back?" So think about these things have to be planned, and there are pragmatic aspects that need to be considered as well as the human.
So things have changed dramatically in the employment arena in the past 2 years. What, from each of you quickly, do you think will change in the practice of employment law over the next 2 to 5 years or even out further?
Well, obviously, I think the hybrid work model is here to stay to some extent. Probably the best thing I've heard during all this was someone who was commenting, and obviously they had an interest in it. They were a big landlord in Manhattan, but they said no one's ever going to be discovered over a Zoom call. So I think people are going to start coming back into the offices as soon as they can. There's not going to be this 2 tiers of workers, one that are just remote and one that are there getting the promotions. And I think that's eventually where we're headed.
I agree. I do also agree with the sentiment that this has given us an opportunity to sort of recalibrate, and that a lot of employees are going to be more concerned about bigger picture and career progression and work-life balance, which is a phrase I know that probably grinds on all of us. But those are things that are critically important as compared to coming on board and doing all of my discovery or drafting all my interrogatories and paying dues. Paying dues is sort of a concept I think that's come and passed, right? Like, so now it's how do we bring value? How do we add value to these employees' lives and truly make them feel accepted and like they have a path forward to keep them? And if that's not happening, they will be gone.
I think a lot of companies and HR realize how much they don't know and how complicated the laws are, seeing the red light, green light, and all the changes at a federal, state, or local level, or even company policy. So I think there's going to be a huge increase in what I call advice of counsel work, where they're phoning a friend, getting resources, because there's no way you can be a specialist in all of this if you're a generalist at a company.
Dispute resolution. I think dispute resolution is it's already an emphasis in the courts. Anyone who litigates sort of knows that most judges, some require it. They really encourage dispute resolution. But one of the things the pandemic is doing is really emphasizing time delays. So many of my cases are being delayed just because of the pandemic, and it's nobody's fault. As JJ indicated earlier, none of us have experience dealing with the pandemic. But I think now all of us, courts and law firms and attorneys, are going to have to think about doing things more efficiently and resolving these tough issues in a manner that considers the emotional emotional stress and strain that an employment issue can bring about.
So as to what's going to change in 2 years, so first of all, Terry is going to become that best practices partner in our firm. But when I was thinking in advance of this, I think teleworking remote is not here to stay. I think it's going to be gone. And I thought I would be really an outlier saying that. So I'm not hearing that I was that much of an outlier. Maybe 2 years, it might still be here. 5 years, nope. People are going to be back in the office. So you can prove me wrong in 5 years, but.
I think people will be back in the office, but I also think that what it means to be in the office is going to change.
All right, I will compromise on that.
I think when we return to work, there is still going to be a lot more hybrid. I think there are going to be a lot more flexible work relationships. And as what it means to be at work changes, I think the law is going to have to advance to account for that. So if I'm working from home and, I have some sort of incident while working at home, am I at work? And so all of that is going to have to catch up to what we're actually doing.
Thank you for the wonderful insight. I think that brings us right to the buzzer. We appreciate everyone's time.